Hey guys, welcome back to today's video. We've got 3 court cases to go through today. First up is a follow-up on a father who seems far more focused on complaining about paying $25 a month in child support than actually getting a job and sorting his life out. Now let's get into it.
Next matter is Feliciana Garcia versus Jesse Gonzalez, file 17-16703-UM. Is Mr. Gonzalez present with us? He has not appeared for the court. Ms. Kraus, do you have any contact with Mr.?
He just hasn't unmuted yet.
All right, thank you. Mr. Gonzalez, are you with us?
Yes.
Can you turn on your video, please?
Can you hear me now?
I can. Thank you much for being here. This is a show cause to monitor your compliance with making specific payments. Ms. Kraus, what kind of payments has Mr. Gonzalez made since the last court hearing?
Pursuant to the last court enforcement order, the defendant was to pay $25 by September 30th to be compliant with the order. He did not. He only made the payment prior to the hearing on 9/11 and nothing additional in September. He did make a payment in this month in the amount of $30 on October 13th, which did disperse on 10/16. Based on previous information in the support enforcement order, it was indicated by the court that the court would find the defendant in contempt if the full monthly payment is not made, and this would be a second or subsequent finding with him eligible up to 90-day commitment in jail.
What's going on, Mr. Gonzalez? Why aren't you making your payments when you're supposed to make them?
I just don't got it, Your Honor. I'm trying my best out here. I'll just any little bit I get, I save it, and as soon as I get it right out that way, because I don't live out there, I get it right and I drop it off.
So what are you doing to make money?
I live right here. Well, I've already talked to you. I don't know if you forgot it or not, but I work here. I gotta work so many hours, and then on top of that, when you guys took the $3,500 from this lady, I had to pay that back every month too. So I'm paying that back and paying you guys. I'm all over the place right now, but I'm trying my best. If you guys would have never took that money from her, it would have been a lot easier for me making payments on time. But since you guys did that, I'm stretched out right now, and I get it. You guys need the money, but that's where I'm at.
Okay, Mr. Gonzalez, every month you tell me that you're doing your best, but you won't change what you're doing, and we keep running up against this. Mr. Gonzalez, you can't talk over me. Mr. Gonzalez, you can't talk over me. I'll give you your chance to talk, but you got to wait till I'm done.
Yes, sir.
Every month you tell me that you're doing your best, but you won't change what you're doing. Every month you tell me, I don't have it, I don't have it, I don't have it. It's because you won't change what you're doing. You're living at a place and working there without getting paid a real wage. You can't keep doing that. You're never gonna make your payments. So how do I get you to go out and get a job?
I mean, you guys want to take that $3,500 from her and put me in a tight spot with this lady. Now I gotta pay her too, and pay you guys too. I'm stretched right now. If you guys had to get back her money, I'd have been getting that money that I'm giving her and been paying you guys on time.
Mr. Gonzalez, it's not an either-or proposition. That money was owed from you. She just happened to step in and pay it.
I get it, but it wasn't my money, Your Honor. If you were to give it back, I'd have been making my full payment on time. It would have been awesome.
Owing someone $3,500 for posting your bond doesn't suddenly outweigh the $25 a month you're supposed to pay for your own children. That's like telling your mortgage company you can't make your monthly payments because you're busy paying back the person who stepped in and stopped your house from being foreclosed in the first place.
You are the one who incurred that bill, not the court. That was your responsibility.
Okay, I'm not going to say anything. Okay, Your Honor. So I'm doing
you haven't answered my. Go ahead, Mr. Gonzalez.
I'm going to continue to do my best, Your Honor. That's all I can tell you. Before, I've never paid nothing in my life, and now I'm really, really trying. So whatever you want to do, I'm here. I'm a man. I'll deal with the consequences. I'll just continue to do my best.
What I want you to do is get a job that pays you money instead of just giving you a place to stay. You're not doing your best. You're hanging around there and not doing jobs. You need to get out and get a job and go to work. There's nothing that prevents you from doing that. You're an able-bodied man. Here's the options. You either go get a job or you go to jail. Those are your options right now. Which do you want to do?
I'm going to continue to do my best.
No, that's not an option. That's telling me you're going to do the same thing you've always been doing, which is not enough. You either go get a job.
I'm kind of committed to her right now. It's messed up, but.
Mr. Gonzalez, listen very carefully. You have two choices. Go get another job or go to jail. Which would you like to do?
I mean, I'll look for a job.
Your Honor.
Mr. Gonzalez, listen very carefully. Not look for a job, go get another job, or go to jail. Those are the only options that you have.
Well, I'll look for one. I'm a convicted felon. I'll look for one for sure. I'm a convicted felon. I'll look for one though. I know you're trying to press me like that, Your Honor. But whatever makes you feel better, I'm gonna do my best. If you want to put me in jail, and not get anything from me, I don't know what else to tell you. I'm not gonna lie to you, but I will look. I will start looking. But I'm not gonna sit here and lie to your face either. You know what I mean? Like, you're a grown man. You're a judge. I respect you. But I'm gonna do my best. I'm gonna look for a job. If something opens up, man, praise the Lord. I'm just going to continue to try, Your Honor. I'm not going to give up. That's what I'm trying to say. I'm not going to give up no matter what.
Ms. Krause, did you have anything else to add?
I did want to remind the court, since the arraignment hearing, when the lady that posted the bond for him did indicate, because you did ask her in regards to that amount of money, she'd indicated, and I did reference that at the last at the last hearing as well, is that she indicated she wanted him to address his friend of the court matters before repaying her the money that was forfeited as bond.
Well, so much for the excuse that he owes someone else $3,500 and therefore can't manage to pay his child support. And I don't know who posted his bond, but at least she seems to understand that his responsibility to his children comes first before paying anyone else back.
Thank you for that reminder. Mr. Gonzalez, when was the last time that you held a job outside of what you're doing at that place where you're staying right now?
I worked at the Keg for a lot of years, but I started drinking there, so I quit because I'm a recovering alcoholic. So I don't work at bars no more.
When was the last time you had a job outside of where you're living now?
Last year for Brandon, landscaping. That's it for the summer.
All right. You have 30 days to find another job. If you do not find a job, you will go to jail for 7 days. When you get out, you must find another job. If you do not find a job, you'll go to jail for another 7 days. Do you understand what I'm saying to you? We're going to keep doing this until you get another job.
All right.
That will be the order. That will be the order of the court. You'll get a notice for next month. I'll see you in 30 days. Have a job, make your payments.
Sounds good. Bye-bye. I can't leave yet. I got another one.
This is the second matter involving Mr. Gonzalez. This is Melissa Ricecroft versus Jesse Gonzalez, file 18-17322-DS. Ms. Krause, can you tell me what the status is on this matter?
In regards to the status on this case, it was adjourned to monitor compliance with making the specific payment of $321. It was indicated that the defendant was expected to pay $121 by September 30th to be compliant. He did not. He only made a specific payment prior to that September 12th hearing in the amount of $200. No additional payments were made in September. He did make a payment a specific payment in the amount of $200 on October 13th. We would just be seeking the same as prior in regards to enforcing that order.
All right, same thing, Mr. Gonzalez. You've got 30 days to get a job. If you don't have a job, I'm going to find you in contempt and send you to jail for 7 days.
Sounds good. I'll do my best. See you in 7 days.
See you next month.
See you next month. Yep.
All right, so he's got a month to start acting like a self-sufficient adult, meaning getting a real job, not one where pay conveniently comes in the form of a roof over his head. If not, I guess we'll be circling back for yet another update down the line. Now we move on to a civil trial where the defendant might actually have a defensible position if he were willing to do the bare minimum and prove it. Instead, he seems to expect everyone else to build his case for him while he sits back and contributes nothing.
All right, so we are back on the record. This is file 2402367, SC Ignite Credit Union versus Flores. Mr. Flores, you said that at this point in time, you do not think you owe the credit union back this $1,566.71. Is that correct?
Correct.
All right. Then I'm going to have proofs there with you, Becky. First of all, could you tell us your whole name and tell us what it is you do for the credit union?
Sure. My whole name is Rebecca Lynn Aldridge. I'm a collection specialist for the Ignite Credit Union.
All right. And then we are here on Mr. Flores' case. What is the nature of the action here? What is it that you're saying has happened that he would owe money to the credit union?
Sure. So he had an account with us, a savings and a checking account that he drew negative. And with that account being negative, was never paid back. So he owes us money for the negative checking and savings account that he had with us.
And that's the balance, $1,566.71.
Yes. And he is stating that he was in jail. These transactions happened in the beginning of the year, and he didn't go to jail until the end of the year.
All right.
So he was not locked
up. For 2 years. I was in jail for the last 2 years. What are you talking about?
Okay, so sir, let me explain how this goes. And this checking account is just his name?
The checking account is just in
mine.
his...
I just got out of jail, Your Honor. You can look me up. I went to jail back on December of whatever that year was. I didn't get out till July 9th.
No, sir. Sir, we have to be more specific than that. You can't say whatever that year was. When were you incarcerated?
December of 2022. All the way through. Correct. All the way through.
And then when did you get out?
July 9th of 2024. 3 months ago.
So you were incarcerated for about a year and a half, a year and 7 months.
Yes, sir. You can look me up. I left from Allegan County right there. Look me up.
And then, and that was here in our jail?
Yes, sir. I went from there to prison.
All right, because that's not correct, sir. You can't be locked up in jail for over a year.
Do you hear what I said? Do you hear what I said, sir? I went to jail for 4 months.
Listen to me. Jail is when you're locked up for under a year. Prison is when you go for more than a year.
I know that. Do you hear what I'm saying, though? I got locked up in Allegan County.
You just told me you were here in Allegan County Jail from December 2022 to July 2024.
No, from December of 2022 till April 10th of 23. Then I went straight from there, from Allegan County, straight to prison until July 9th of 2024.
We have him on ATM footage. Before that. We have him on cameras.
I mean, if they got him on camera, then they've got him on camera, and he'd have to prove it wasn't actually him in the footage. But even if that were true, he could still claim he let someone else use his card, or even had the card issued in his name and allowed someone else to run it, figuring he could later argue he was in jail and therefore couldn't be the one making the transactions.
Ms. Aldridge, it really wouldn't matter. For purposes of a small claims hearing. So, sir, essentially, here's what's happening. Someone is spending money in an account that is solely attributable to you. And so
Well, that's
there's
fine,
been
but
an
she says they got
overdraft.
me on, they got me on
Mr.
camera. That's impossible. I was
Flores.
incarcerated.
Mr. Flores.
Go ahead.
And I
Yes.
told her, stop talking. It's my turn. I know it's hard when you're on the phone rather than video, but I'm going to talk
Yeah, I'm
for a
sorry.
while, so just listen.
Yeah, I'm sorry. I don't understand how
We
it's
wouldn't
made.
even, okay, listen, we wouldn't even get into whether or not that's you or not, okay? For purposes of a small claims hearing. So here's the situation. You have an account with the credit union. That account is in your name. In other words, you have the power to draw on that account, and you have the power to authorize people to draw on that account. And someone could draw on that account that doesn't have permission, right? Those are the three scenarios. In the first two scenarios, if this account were to get overdrafted, which it did, so just so you understand, essentially what they're saying is someone keeps either writing checks or taking money out, and there's no money in this account to cover it. It has a negative balance, $1,566.71. You understand what we mean by that, right?
Yeah, I understand that, and I also had overdraft protection.
And exactly how would you have intimate knowledge of the protections on the account if you weren't the one who created it? Something tells me he isn't being exactly truthful in this situation.
All right. So here is how this works. If it was you, then of course you owe the money back to the credit union.
Exactly.
Now say it was,
I'm an adult.
okay, but now, like I said, stop talking and just listen to me. If it was your friend Bob and you told Bob, oh, here's my card, go ahead and use the card, and Bob did it, that still means you would owe the credit union back the money. You understand that, right?
Yeah, I never
So
gave
if it was
anybody.
you,
Okay.
if it was you, or if it was somebody you let do it, you owe the credit union back both times. Now, if somebody did it that did not have permission, like you say you were incarcerated, someone got your card and is taking money out of the ATM. At the end of the day, you still owe that money to the credit union. Now, there's two things that you could do instead of owe money to the credit union. One is you could go make a police report and say, hey, look, the credit union says I made these withdrawals. There's no way I made these withdrawals. I was incarcerated. And what you would have is a police report to then show me, and then I would say, hey, you reported this as a crime. I'm not going to order that you owe that to the credit union. Or
all I have to do is make a police report.
Listen to me. Or if, say you let Bob, you told Bob, oh, hey, you can use the card while I'm incarcerated, and Bob racked up all the money. You would still get ordered to pay the credit union, but then you could be a plaintiff, and you could sue Bob and say, hey,
I don't give
Bob
anybody
made
permission
me
for
go
anything.
negative on this balance. I'm
We don't
just
even
telling
need
you
to
what the
talk
different
about
scenarios are. But right now, with the evidence that I have, you can tell me all day it wasn't you. You didn't file a police report. You didn't say it was a crime until you got sued in small claims. I would order you
I
have to
went to
pay
them
this
when I
money
got
back.
out of jail.
Listen
When I
to
got
me.
out of prison, I went to them.
Okay, but that was July of 2024. Did you ever report this as a crime?
No, because I went to them and told them I was going to get the proof of incarceration. But now that I figured since I was going to court, you could easily look me up and see that I was incarcerated and see that I didn't do these transactions.
Okay, listen.
That's simple. That's simple.
Here's the problem. You're telling, as a judicial branch, I wouldn't do your investigation for you to prove that it really wasn't you. What I have is a credit union who is due this money.
Okay, who do I got to give my proof of incarceration to?
Well, if you were actually listening to the judge, you'd understand that simply providing proof of incarceration doesn't really get you anywhere, because it doesn't rule out the possibility that you still authorize someone else to use the car while you were locked up. The judge already made it clear that the proper step would be filing a police report claiming you're the victim of financial fraud, and then backing that up with your incarceration records. Of course, that route usually comes with its own problem, because it likely means someone in his circle is going to get named and end up taking the blame.
Well, first of all, you don't have any proof of incarceration. You're just
Yes, I
telling me
do.
you
It's
were
right there now.
incarcerated.
I have it right here on me. What do you mean I don't have proof of incarceration? I have it on me. You want me to send you a picture?
Sir, are you in court right now?
Yes, I'm in court, aren't I?
On the phone?
Yeah.
So you don't have any proof of incarceration to hand me right now. You also don't have any proof of incarceration that you sent to court when you knew you were being sued for this very same matter.
Whatever. That's irrelevant. I was in prison, dude. Carry on though. What do I got to do?
So here's what you have to do. You're going to get ordered that you owe this money to the credit union today. Well, you can say that, but until you report it as a crime, you're essentially just saying, nah, I don't owe the money.
I was incarcerated, Your Honor, or whoever you are, referee.
All right, listen to me. When did you find out you were getting sued by the credit union?
About 4 days ago.
All right.
When I got served.
So you only got served to be here 4 days ago?
Something like that. They're trying to find me, and they know I'm on parole, and whoever the bailiff was wouldn't even call my parole agent or anything. It was ridiculous.
Sir, why is everyone else supposed to solve your problems for you?
Because they're the ones looking for me. I ain't looking for them.
This claim and affidavit was filed in September.
I don't care when it was filed.
Okay, so I am going to order damages in the amount of $1,566.71 and costs in the amount of $119.16. Sir, there was a path that you could have easily avoided this, but you did none of it, that work.
Nobody fucking told me anything. What are you talking about?
What do you mean no one told you anything? You got a piece of paper saying you're being sued by a credit union for overdrafting your checking account.
Whatever, dude. You're ridiculous.
You showed up in court.
You're not a judge, are you? You're not even a judge. You just told me I wasn't in court. Did you not 5 minutes ago just tell me I was not in court or something? Come on, guys.
Yeah, you're technically in court, but not actually there in person to present anything. And that's the problem. If you had submitted your evidence before the hearing, it might have actually helped your case. Instead, you're just showing up with "trust me" as your main argument.
Yes, because you said you had proof on you to give to me.
What's your name again, sir?
Dan Norbeck.
So you're not even a judge?
No, sir. I'm the magistrate who is hearing your small claims hearing right now. So your right to appeal is, if you disagree with this finding, you have 7 days to appeal this. That window of opportunity closes after 7 days. Secondly, you must come in and file for that appeal in writing. You cannot just call the court and ask for it. Do you understand your rights on appeal?
No.
Okay. Which one of those two parts do you not understand, sir? I could explain it to you again.
Oh, I'm sorry. I'm good. I was talking to somebody else.
Oh, okay. Then you are all set. I will draw this up and send it out to parties. I'm going to go ahead and release parties at this time.
Thank you.
All right, that's the end of that hearing. If he was actually innocent, it would have been simple. File a police report and present the evidence to the court. But that didn't happen. Now he's in a position where he'll likely have to post a bond just to get a second hearing, and that bond may end up matching the judgment amount. Now we move on to the final case, where we've got an individual who decided it was a good idea to bring a gun on a school grounds. And then, when questioned by police, try to downplay it by claiming it was just a toy.
Hello?
Mr. Rice, there you are.
Oh my gosh, I don't know what's going on here. The phone just, that red light or the red line came out.
You're okay.
All right.
Mr. Rice, you were present a couple minutes ago when the court explained the procedure for these hearings today, correct?
Correct.
So you understood the court to instruct you that you must select from one of three options to protect your rights, correct?
Yes, sir.
Thank you. Mr. Rice, the citation before the court indicates that on August 24 this year at about 2:15 in the afternoon, you were operating a motor vehicle in the city of Royal Oak, 1500 Lexington. And at that place and time, strike that. I don't see a vehicle here. You possessed a concealed pistol on Royal Oak High School grounds. And let's see here. Our CPL was produced. Pistol was a registered firearm. So it's a fail to disclose to peace officer civil infraction. This is not a crime. You have 3 options today, Mr. Rice. You can admit responsibility, you may admit and explain, or you can deny responsibility, and we will take testimony. What do you wish the court to do?
So, admit, or the second one was what?
You can admit and explain, which is usually what most folks do, or you may deny responsibility and we'll run a quick trial.
I'm going to deny responsibility.
No
There's
worries.
a lot.
Please raise your right hands.
Yeah.
You both solemnly swear the testimony you shall give before this court should be the truth, so help you God.
Yes.
Thank you very much. The officer has the burden, Mr. Rice, then it's your turn.
Yeah, Your Honor, on August 24th of this year at about, probably would have been around 1:30 in the afternoon, we were dispatched to someone behaving strangely and recording their interactions with people. Upon arrival, we spoke with somebody who indicated that that individual was walking on the track of the high school. Described their strange interaction while he had a small child with him, and then walked over to drove over to the track where we had observed the gentleman walking on the track, and then was flagged down by a second individual about the guy on the track who had possibly had pepper spray in his hand, but also had other types of weapons with him on his person.
Okay.
And then Mr. Rice approached us. When he approached us, he did not have pepper spray in his hand. However, he had some sort of body-worn stuff on, which had a baton, pepper spray, and under his left armpit, I believe it was his left armpit, was displayed a handgun.
Well, that changes things a bit. In Michigan, open carry of a firearm is generally legal, even if it's holstered, since it's still treated as open carry under state law rather than concealed carry. That said, once you start placing a weapon in a position where it's partially covered, like mounted on the outside of a tactical vest under the arm, it becomes less obvious to an average person that it's a firearm at all. At that point, it can start edging into concealed carry territory, depending on how it's perceived. That interpretation lines up with cases like People v. Concave and People v. Clark, which essentially support the idea that a firearm isn't considered concealed unless it's hidden from the casual observer.
After the interaction, Mr. Rice at no point made any effort of telling us he had a CPL in a weapon-free school zone. And in fact, told us that the gun was a toy gun, that it wasn't real, and attempted to make us ask no further questions on it. When the gun was retrieved, it was, in fact, a registered firearm registered to Mr. Rice, and he did have a CPL with him. When I requested the CPL and his Michigan ID, he handed the CPL to me, but initially refused to hand his ID card to me until a supervisor got there. Again, throughout this interaction, Mr. Rice made no effort of displaying his CPL to me and notifying me that he possessed a CPL while carrying a firearm in a weapon-free school zone. And also, when asked about the weapon, it indicated to us that it was a toy gun and not a real firearm.
Thank you. Is there anything further you wish the court to know, Officer Nadrowski?
No, I would say that Mr. Rice's choice of carrying the firearm could be considered concealed. It was in a holster underneath a strapped band. A CPL holder is allowed to carry open carry to and from school drop-off. During August 24th, school was not in session yet, so he was not to and from drop-off for school. Carrying his weapon outside of the code as it's written.
I see. Okay. Is there anything further?
I have nothing further.
All right, Mr. Rice, it's your turn. What would you like the court to know?
Well, can I ask you a couple questions, Your Honor?
Well, I can't give you any legal advice.
No, I what I want to know is this when informal? Do you have the authority to dismiss or what is the informal?
Informal simply means the plaintiff in this case, that's the city of Royal Oak, is not represented by the prosecutor. If this were a formal hearing or if it was at the level of a misdemeanor, the city of Royal Oak would be represented by a prosecutor.
Okay. So you want me to tell you now?
Yeah, well, now you have the floor.
Yeah, right. Okay, so there's a little bit of a story here, storyline here. It might take 5 minutes, if it's okay with you, if you don't mind.
That's fine. That's why we're here.
So, to begin with, it's important to know, let's start from the beginning. Why did Mr. Nadrowski and his partner, Mr. Stuglin, stop me in the first place? Here's a little background information. I live about a block away from the school, and I walked near there every day for 5 months, for 3 hours a day. I estimated 1,500 miles, 450 hours, and 98% of those 1,500 miles were walked on public domain streets. Crooks, Normandy, and Lexington Boulevard. Those are maintained by the city of Royal Oaks. And I preferred there because I was subject to a lot of daily harassment issues. And at times I was forced to temporarily alter my walking pattern to try to avoid those harassing activities. I wore a body camera every day for legal purpose. So I had everything that took place on that day from what these two people allegedly said, which was a lie, and all through the conversation with Mr. Nadrowski, Struggling, and his supervisor. One point I want to add out right now is that I did hand, and it's on video, so he can't say that it didn't happen. I handed him my driver's license and CPL. At first I didn't want to give him the driver's license because we were at a different stage. So let me continue with that. So I was forced to alter my walking pattern to avoid these harassing activities. And if
what are these harassing activities again? Please remind the court.
Just what is people walking their dogs with no leashes, when their dogs without a leash.
Okay.
I had one couple of threats. People going 45 miles an hour down Crooks Road on an e-bike.
Oh yes, the dangerous e-bikers and unleashed family dog defense. Clearly justifications that totally warrant rolling on his school grounds in full tactical gear with a concealed weapon.
People walking dogs on the road, which would force me to alter, So at times I would change my pattern. So 2% of all my walking was out in the main streets, and I felt safe there because people could see me, right? So but school's out. When school's out, there wasn't a lot of traffic there. So if I may, can I turn this phone around and show you the?
Sure.
Yeah. Okay. So here is just the ground. Here's Normandy. Can you see that? Crooks. And and Lexington Boulevard. So
Sure.
almost 1,500 miles was logged here. I'm a walker. I'm retired, you
That's
know.
great.
And so sometimes when I'd have harassment up here, I would go down here and I walk the parking lot. But the school's way over there. So here is where one of the persons who I call him swatter, or someone who maliciously I call them gang stalkers. And I don't know if you know what gang stalker is, but it's a real issue. Anyway, so then I walked over here, did a few laps, and I don't know what Mr. Nadrowski's talking about. You know, I never said a word to this person. And I came out here, and here is where Mr. Nadrowski and I had met, and he just drilled me. He went off on me like, you know, in fact, here's the words why I'm pleading not guilty. So I'm saying I'm not guilty based on extenuating circumstances, harassment, intimidation, coercion, gang stalking, and false reporting or swatting by those two people that I showed you in that area. That distance was a quarter of a mile. Roughly a quarter mile apart. And that all of this occurred 30 minutes before Mr. Nadrowski even addressed the school zone gun issue. And so the false charges was this. So this is, where am I at here on this thing? And this one harassing incident, which incidentally I have on video, if you want to watch what transpired. And
well, the court isn't necessarily concerned about what you believe to be triggering events or the necessity for carrying the weapon or what have you. The court is principally concerned with the fact that it appears as though you were on school property, and at least according to the sworn testimony of the officer, you initially failed to disclose that and in point of fact tried to obscure that fact. So anyway, the court doesn't need to see your video, but please continue and conclude your testimony.
Okay. So I was stopped by Mr. Nadrowski. He immediately and aggressively falsely accused me of it. So the point is, I'm feeling intimidated right away. He's aggressive with me, and the comment was made out of duress or out of anxiety, supposedly.
What comment is that?
Well, I said it was a talk. You know, he said, well, let me go find out back there what he said that was aggressive enough to put me in a put your stick down. What are you doing? Well, what do you mean? What am I doing? This is Nadrowski, Mr. whatever. You're approaching people very aggressively. I don't understand what you're talking about, Mr. Johnson. You're approaching people very aggressively. Like what? We're here to talk to you to see what kind of problems you're having. I don't have any problems. I've been coming here.
Mr. Rice, I hate to interrupt you, but you're going far afield of the scope that's before the court. This is an informal hearing. This is a civil infraction. You have not been charged with a crime. And what, if anything, Officer Nadrowski may have told you in terms of his investigation is not necessarily germane to the issue at hand. If you're suggesting to the court you somehow believe you have a justification for carrying the weapon on the school property, are you a security officer at the school?
I was for several years.
Are you now?
No.
Okay. Were you dropping off a child at the school?
No.
Okay.
But
you may conclude your testimony. The court doesn't want to interrupt you. Go ahead.
All right. So they started asking me for driver's license, and then they said you're acting like a weirdo and all these things. So between when Mr. Strugley came in, it was I was feeling like I was backed. You know, I was trying to slow the questioning down because they were accusing me, right? They're accusing me of acting weird and so on and so forth. And I was starting to feel like it was going to turn into a physical altercation.
You're acting pretty weird, dude. Maybe you shouldn't be carrying a concealed firearm or even have a permit if your first reaction to someone riding an e-bike too fast is to escalate things that far.
And at one point, he said to me, he goes, well, let me just continue for a minute, and then you could decide what, but so the point is, I was feeling like, let me get back to where I was right here. I initially said it was a toy gun, but that was an impulsive response that was made out of duress or heightened concern provoked by his aggressive, intimidating, harassing, and false accusations questioning. I was trying to slow the whole conversation down before it got what I felt was turning into a physical altercation, but he was going to make it physical. So there was intimidation there. The gun was visible on my side, and I wasn't hiding anything, and that's how he saw it and commented on it. It wasn't concealed. When he asked me for my CPL license, I gave it to him. I believe they knew it was real. I even told their supervisor when I asked for a supervisor, because it was starting to get to a level of, he said to me,
okay, Mr. Rice, I advised you once before, the back and forth, the tick-tock between you and the officers is not germane. The court asks you if you meet one of the exceptions for possession of a weapon on school property. Apparently your answer is no, correct?
Yeah, I think that I was just trying to have something to protect myself.
All right, very well.
I mean, but can I finish?
What is it, sir? So that's why I said what I said. I said, okay, the court's not really concerned with why you said what you said, okay? This is more or less a strict liability circumstance. So what you said, what they said, it kind of just boils down to, where were you? Did you have the weapon? Did you initially fail to conceal? Okay. The court believes it has a very good handle, as well as it can at this point, around the facts and circumstances. And at this point, the court will turn to Officer Nadrowski for any rebuttal testimony.
Well,
yeah, Your Honor, it happened as I said. I don't know what his feelings are about how he feels I acted that day. I assure you my demeanor is, as you see it here today, this is something I encounter from time to time, people that try to get a rise out of me, and it doesn't work with me, unfortunately. However, I did find that he was violating his CPL and failing to notify me of it.
Okay. Mr. Rice, again, the court believes that, you know, in your mindset, you believe you were acting in good faith. The bottom line is this: the civil burden of proof is a mere preponderance of the evidence. This was a circumstance, quite frankly, where you could have been charged with a criminal offense, but that did not occur. All right. So at this time, the court is finding you responsible for the infraction. Please stand by. This is somewhat exotic, so the court needs to find out what this sanction is.
well, Your Honor.
Yes, Mr. Rice, the sanction for this is $200. That is payable through the pay portal on the court's website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. This is due within 7 days. Mr. Rice, if you take exception to this court's ruling, and the court has the impression that you might, you have an absolute right to appeal this matter before the chief judge of the district. The matter would be placed on the formal hearing docket, and at that juncture, on the formal hearing, the city would be represented by City Prosecutor Ryan Coulldn. So $200, either as a bond or as a fine, within 7 days. That completes your hearing. No matter who or what you think is threatening you, you can't subjectively change the rules to meet your personal circumstances, okay? Ours is a rules-based society. The yellow stripe of paint going down the road is what separates chaos from order. The court indicates what the ruling is, what the sanction is, and that is your hearing, sir. Good luck to you.
Well, if protection from nothing is what you need, then you probably shouldn't leave the house without wearing your foam helmet. Next voice, next voice. That wraps up the videos for today. In my opinion, this individual seems like he needs padded walls for safety more than he needs to be carrying a concealed firearm. All three of these cases are recent, so if there are any updates, and I'm fairly certain at least one of them will develop further, I'll cover them in a future video. But if you enjoyed the video, feel free to hit the like button. If you didn't, hit dislike. Either way, leave a comment below and subscribe with notifications on so you don't miss any future content.